Okay, a few words about Donald Trump's financial records, tax returns, and all that. Everybody knows that there were two rulings this morning from the Supreme Court, both of them 7-2, which is itself a story. There is a ton of confusion in the media, which loves false equivalence, right? They always like to split the baby. They always want to be able to say, oh, you know, each side is a little bit right. I'm with Neil Katyal on this. He is a renowned lawyer and commentator, and Trump did not win anything today. As a legal matter, Trump lost. So the media is having a really hard time distinguishing between a legal win and a political reprieve, right? What happened here gives Donald Trump a little bit of time. It makes it less likely that his tax returns and financial records will be released before the November election, and obviously as a political matter, that's important. But to say that Donald Trump did anything except lose in these two cases as a legal matter is absolutely not, it's not correct. Let me show you a screenshot I took earlier today, right? In the very same screenshot, on the same screen, you can see one outfit reporting that the Supreme Court blocked Trump, another outfit reporting that the Supreme Court blocked Congress, and then in between, you know, sort of, oh, the Supreme Court decided some cases. So we've covered all the bases. Here's what the Supreme Court said. First of all, it shot down Donald Trump's I am the king defense, and in no uncertain terms. The president enjoys no immunity. The executive is not immune from subpoenas in criminal cases, and we'll talk more about that here in a minute. And the court settled once and for all that yes, Congress is entitled to issue subpoenas even to the executive branch in its efforts to gather information. Now, we've got to put some more meat on those bones, but the fundamental claim by the president was, I don't have to answer any subpoenas from Congress. They have blanket refused to answer subpoenas from Congress, and I am totally immune from prosecution at the federal level, at the state level. Nobody can charge me, nobody can investigate me, never mind charge me with a crime as long as I'm the president. Literally, he was arguing that he could shoot somebody on Fifth Avenue and couldn't even be investigated. That's gone. The Supreme Court rejected that. Even the dissenting justices rejected that claim. It seems Donald Trump understands at some level that he didn't win. I was almost surprised that he didn't claim to win, but Donald Trump is racked with anxiety. You know, if you read his the book by Mary Trump, the central claim seems to be that his greatest fear in life is being discovered, being found out. Getting caught, being what and who he really is. So he doesn't want this information out, and what he knows, so his impulse to claim victory was overcome by his anxiety. That he knows now what's hanging over his head. He lost. Okay, let's divide these cases up. Again, one case comes out of New York, where a state district attorney, Cy Vance, issued subpoenas through a grand jury, and for documentation for some criminal case or cases that the local prosecutor there is building. In that case, the court said there is no immunity. There is not even a higher standard or burden for a prosecutor to get a subpoena, to issue a subpoena, just because the recipient of the subpoena is the president or somebody, or third party, in possession of the president's papers. So that's a total loss. That's a total loss. The Supreme Court said you are not immune from criminal process, and that was an open question before today. So that was a very interesting ruling. The court before, in a case called Clinton versus Jones, had said the president is not immune from civil process, but to extend that to the criminal side is something I wasn't sure the court was going to do, but it did, and it did it by a 7-2 vote. So now Donald Trump has that hanging over his head. He knows that he is at the mercy of Cyrus Vance, and this is not a man who wants to be at the mercy of anybody. After today's ruling, he is at the mercy of Cyrus Vance for the remainder of his reign. That is for as long as Cyrus Vance is still in office and chasing Donald Trump. If Donald Trump is reelected, he now knows that his second term will be consumed with what's going on, investigations in New York. This also opens the door for investigations in other states where prosecutors might not have really had a feel for whether it would be appropriate to investigate a sitting president. Now they know. So that's what's happening on the New York side. On the Congress side of things, okay, the other case was about Congress issuing subpoenas. Now, you have to be aware of a rule that has been on the books for decades. Congress, according to the Supreme Court, and in old cases going back to 1930s, 40s, in that era, ruled that Congress has investigatory power, that obviously needs information to legislate, and even that Congress has the inherent authority to enforce its own subpoenas. So it wasn't an open question whether Congress could issue a subpoena. Of course, we now have the new claim, which hadn't been asserted by anybody since Thomas Jefferson, right? A president since Thomas Jefferson, that, okay, maybe Congress has, this was what the Trump people were saying, maybe Congress has the authority to issue subpoenas, but not to the president. All right. As a general blanket matter, Congress does have the power to issue subpoenas, but here's the rule that you need to keep in your head as we talk through this. Congress, to issue a subpoena, has to have a legislative purpose. Okay, so, and this is based on a notion of separation of powers. The executive branch is there to execute the law and enforce the law. Congress is there to make the law, right, not to enforce it and execute it, but to make it. And courts are there to interpret and apply the law. So, so Congress is not supposed to trump, if you will, or usurp the executive branch's prerogative to enforce the law. Congress is not the law enforcement part of our government. So when subpoenas are issued from the executive branch, that's usually for law enforcement purposes. Here we're talking about Congress issuing subpoenas, and they're not supposed to be the ones who are enforcing the law. They're supposed to be the ones who are making law. So the court has said that when Congress issues a subpoena, that's fine as long as Congress has a legislative purpose. What are those purposes? One of the things Congress can do is issue subpoenas when it impeaches somebody, because impeachment is right there. It's a power of Congress. That's a legislative purpose. In this case, Congress did not issue the subpoenas in the context of an impeachment. Let me show you the problem here that Justice Roberts, and before I even go there, how I would characterize Chief Justice Roberts' opinion in the case about congressional subpoenas would be not that it's a partial win for Trump because the case was sent back down to lower courts, but it was a roadmap. That's how you want to think about the Chief Justice's opinion in that case. It was a roadmap. He is telling Congress, you want to subpoena the president, we're not going to stop you from doing that, but we don't want any Congress harassing the president, whether, no matter who it is, for political purposes with subpoenas. You still have to have a legislative purpose. So the court said, look, we're going to tell you how to get information that you want. We're going to give you a roadmap for how to do that. Now, having said that, let me show you the problem. Chief Justice Roberts, and before he set out the roadmap of how we want you to do this, he clearly fired a shot across the bow of Congress. Sorry, that's Laney, my dog chewing on her bone. He fired a shot across the bow of Congress saying, you got to get your act together. And actually, I don't disagree with him on this. In part of his opinion, he talked about one of the subpoenas, at least, or a group of subpoenas, issued by the committee headed up by Elijah Cummings. When you look at this part of the opinion, here's what the Chief Justice is saying. When I look at this, he didn't say it in these explicit terms, but this is clearly what he is getting at. When I look at this, it looks like this is an investigative, right, not a legislative subpoena. It looks like you were trying to uncover wrongdoing. Now keep in mind, that kind of law enforcement, right, uncovering wrongdoing, investigating crimes, is up to the executive branch. And look at the very end of this little snippet, this little passage. It looks like the part here where Elijah Cummings says, oh, and also there might be some legislation that we want to pass. So legislative purposes, impeachment would be one. The obvious other one, and the big one, is passing legislation, passing laws. That's a legislative function. Congress needs information to base its policymaking on. So when it wants to pass a law, it needs information, and the court said, and it is entitled to that information. And if people don't want to cooperate with Congress, Congress can subpoena that information. But again, when you look at the snippet, the part about, we might want to pass some legislation about this, there's a number of laws we're looking at, that seems like an afterthought. And again, I don't disagree with the Chief Justice on that. I think the Democrats could have done a better job in crafting their subpoenas, and also in making the case that they have a legislative purpose. At any rate, with that in mind, Roberts said this: here are 4 things we're going to, so talk about a roadmap, right? These are factors. If you're a student of mine, I make a big deal out of that. These are not elements or categories or anything. The court said, we want to look at the following 4 factors, and the court even said there might be other factors as well, but these 4 are the ones we want to focus on. So here you go, Congress, when you want to subpoena the president. I wrote these down. So, number 1, you need to tell us why you need the president's papers. And that's another way of saying, and he actually said this quite clearly, why can't you get the information some other way? Okay, we want to maintain some separation of powers. Again, we want to make sure Congress isn't using its subpoena power to come after a president for political reasons. The presidency, we want to respect the office of the executive. And so when you're actually locking horns with the president himself or herself, tell us why you can't get the information you want anywhere else. He's saying, wink, wink, right? Tell us why you need the information from Donald Trump, and why, or at least the information about Donald Trump, and why you can't get this information somewhere else. We're going to come back to that. But that's the first factor. Right, why do you need it from the president? Why do you need the president's papers? The second factor, the court says, is be careful what you ask for. I would call this careful tailoring of the subpoena. The subpoenas in this case were kind of all over the place. Some of them wanted records from, I can't remember the exact dates, 2010, or before. What Robert says here is, look, the subpoena can't just be a fishing expedition. If you want to pass a law, right, about something, and you want information, and you want it from the president, or you want the president's records, be precise about which records you want, from when, and why. So, careful tailoring of the subpoena. When it looks like the subpoena, like there were kind of random dates selected, 2000, 2010, whatever, just something divisible by 10, of course, going to say, look, we want to be careful about this. You're entitled to information, but carefully tailor the subpoenas so that you're asking for only the information that you need if you're talking about getting into the president's papers. Third, the court says you need to be more specific about, you can't just say, well, there's some laws we're considering. You need to be more specific. The court said the more specific, the better. What are you thinking about legislating on? Because again, we want to make sure there's a legislative purpose. What laws are you thinking about passing? Be specific about that so that we can evaluate whether you have a legislative purpose. And finally, the court says, be mindful of any burden you're placing on the executive branch. Litigation, as anybody who's been involved in litigation knows, litigation is a time-consuming and energy-consuming process. Now, with these 4 factors in mind, let me review that really quickly. Tell us why you need the president's papers, why you can't get the information you need somewhere else. Be careful about what you ask for. Don't be overbroad. Tell us more specifically what laws you're thinking about passing, and don't waste the president's time unnecessarily. Okay, so those are your 4 factors. Here's what I would suggest, and I think I would even encourage people who are watching this to get to your member of Congress and make sure that they're getting the message. 5 things Congress needs to do, and they need to start doing it right now. I'm not saying that they're going to be able to do this before the election, but the sooner they start, the better, so that we have whatever information Congress needs and the public needs to consider the future of the presidency itself. Number 1, Congress, draft some proposed legislation, and you're not going to be able to complete that process. I'm talking proposed, an outline. Get some preambles written, get some whereases written. get a thumbnail sketch, get statements of purpose, right, for legislation. Get these things written, and it's very concrete. If the court is saying, we want to know specifically what laws you're considering, cross your T's and dot your I's and get some draft legislation going. Number two, right, once you have an outline of the type of legislation you think you want to pass, and by the way, there are plenty of options for that. If I'm Democrats right now, I'm all over this Russia bounty thing. You know, we may have to impose sanctions on Russia. And one of the things that we need to know, this is if I'm Congress, what I'd be saying. One of the things we need to know as we're legislating, passing laws requiring sanctions on Russia, would be what is the extent of their influence over American politics. That includes the president. You know, we need to know, has Russia been trying to influence our foreign policy by renting rooms at a Trump hotel? We need to know if there's any kind of financial, there may or may not be financial mischief going on. But in order to know how to handle the Russians, we need to know why the president, right, seems not to be interested in confronting the Russians, even when they put bounties on the heads of American soldiers. They could take that angle. They could also take the angle that they're, you know, regulating elections, election finance laws. What kinds of disclosure should be required of a presidential candidate in the future? So there are a number of different right options. I'm not a legislator, but I'm just saying it has to be that Congress has some avenues it can take here to try to draft proposed legislation, or at least outlines, proposals, statements of purpose. Second, hold hearings. Okay, once you have your outlines ready and your direction set, hold hearings and make findings, and that way you're developing a record of the kind of information that you have, because the court again wants to know, why do you need the president's stuff? If you hold hearings and make findings, then you go to step 3, which is, see, now you have a record of the holes in the information you need. Now you issue subpoenas that are carefully tailored to fill in those holes, and you demonstrate to the court, we've already done some homework here, but there is information that we need that is only in the possession either of the president or in third parties who have the president's papers. Fourth, be prepared to argue when you get to court why you need information from the president. These are related points, but from the president or from third parties who have the president's papers. The only president right, that we have right now, and the only president who's ever been implicated in some of these foreign entanglements, is Donald Trump. Donald Trump is the issue. You have to be able to make that case that Donald Trump's papers are the papers we need, because Donald Trump is the issue, and we can't, there's no way for us to legislate on these areas, whether it's Russian sanctions or election finance law, whatever. There's no way for us to legislate without identifying how the process has been manipulated and abused, and what we need to do, what kinds of activity we need to make illegal in future cases. We cannot do that without knowing what has happened here. So that would be the next step. Finally, I think this is one thing Congress got right, is go through third parties. The court says we don't want you to burden the president. Well, that's an easy one. You know, do what Congress did. Subpoena the president's banks, financial institutions, money management companies, whatever the case may be. To the extent possible, don't issue subpoenas directly to the president. Stay away from the president if you can. Go through third parties and get your information that way. That way the president might be stressed out, but the president can't say, you've been wasting my time, because the subpoena wasn't directed to the president. Again, based on the 4 factors that the court laid out, there are 5 steps Congress should take. Draft proposed legislation, outline what legislation you are looking to enact, and it doesn't matter if the comeback is, well, the Senate won't pass it. Well, who cares? The House of Representatives is one house. They have authority and to issue subpoenas to get the information that they want. The House can pass, if the House passes a bill and the Senate rejects it, well, so be it. That's not that doesn't affect the calculus here. So set out your legislative goals and specific legislation that you're thinking about enacting. Number 2, hold hearings and make findings. Number 3, based on the holes and the information that you found, issue subpoenas that are carefully tailored to fill in the holes. Number 4, be prepared to explain how you can only get this information, right, how this information all relates to the president, and in this case Donald Trump alone, and that's the information you need, so there's no way to get the information anywhere else. Finally, try to stay out of the president's way by going through third parties to the extent possible. That would be my advice on how Congress should proceed. Cy Vance, the prosecutor in New York, is going to be doing his own thing. Right, I'm sure he's on it already. The Trump team is going to throw everything at Cy Vance that they can. But what the Supreme Court said is, you can file whatever motion and make whatever objection any other citizen can file or make. But there is no special consideration because you're the president. That could be trouble for Donald Trump. Now, 2 things before I leave about why the New York thing is such a problem. Number 1, remember this. I'm breaking things down into a lot of numbers today. Donald Trump does not have a Bill Barr in the New York State Prosecutor's Office. Okay, these are state prosecutions, state investigations at this point, state subpoenas. And so, this is not the Department of Justice at the federal level where Donald Trump has some control of the levers of power over there. This is a completely separate sovereign, New York State, and so there is no Bill Barr to bail out Donald Trump in this case. Number 2, because it's a state investigation that might result in state charges, there's no way for Donald Trump to pardon his way out of this problem. So the Supreme Court has created a huge problem for him. He can pardon, he can, arguably himself, I don't know if we'll ever find out the answer to that question, but he could at least pardon the people around him, when it comes to federal crimes. That's something that I think a lot of people don't realize. The presidential pardon power only applies to federal crimes. So if you're convicted in a state court of murder, under a state law, president can't pardon you, that kind of thing. So he doesn't have a Bill Barr to manage the situation for him. He has Cy Vance, who seems aggressive, who is the district attorney. And number 2, he can't pardon his way out of this. So clearly from his Twitter rant, he's aware. Again, somebody told him, some legal mind somewhere told him, get ready, Fox News and CNN are going to say that this is a partial win for you, but the Supreme Court just told you that they just burned your get out of jail free card. And I think that Donald Trump thought that he was going to have the votes. I think he thought that Roberts would go along with him, and I certainly think he thought Gorsuch and Kavanaugh would go along with him, and they did not. It was an easy enough call on these principles that they did not. So those are my thoughts on the 2 cases from today. I actually thought before going in that the court would rule in favor of the New York prosecutor. I thought that the court would actually go further and just saying Congress did not have a legislative purpose here. And so in some ways the court gave more of a win to Congress than I expected. What the court said is, we're not saying that your subpoenas are invalid. We're saying that these are the 4 factors that courts have to consider, and they sent it back down to the lower courts to consider them. However, the writing is on the wall, right, with regard to these subpoenas that are kind of amorphous, and where passing laws seems to be an afterthought. If I'm Congress, if I'm Nancy Pelosi right now, I say just scrap it and start over, okay? Draft some proposals, one more time, draft some proposed legislation, have some hearings, et cetera, and let's get this done right. And let's make sure we have an airtight case when we get back to the Supreme Court, and the Supreme Court can just say 7-2 or 9-0, whatever the case may be, you have to release the information. We don't want this to go on and on with potentially defective subpoenas floating around in the court system. All right, that's enough. Hope you enjoy watching these videos. If you do, please click like and subscribe and all of that stuff and share. And we'll see you the next time there's something to talk about.